claimant in this case is Rosa, and there are three potential defendants. The Tate Gallery, where Rosa is currently employed, the churches, who may be separate but I will refer to as a group in terms of establishing liability, and Mr. Khan, Rosa's doctor, who misdiagnosed her condition in 2015. I will be advising Rosa on any potential claims and the likelihood of success. The tort of negligence has 5 elements: actionable damage, a duty to take care, a breach of this duty, a causal link between the breach and the harm, and any potential defences. Rosa's cancer comes under the actionable damage of physical injury. In the instance of the Tate Gallery, Lord Bridge states in Caparo that duties exist where they have been established or in situations which can be regarded as analogous to situations where a duty has been found. In Wilson and English, an employer-employee duty of care is established to maintain safety in the workplace, and it is easy to identify the Tate Gallery owes Rosa a duty of care. It could also be said using the Caparo incremental approach that relationships between volunteers and the organisations they are volunteering with are equal to those of employer and employee. Therefore, the churches would also owe Rosa a duty of care, although this may be a more contentious point than a traditional employer relationship. The second element is whether a duty of care was breached, meaning that the conduct fails to meet the standard of reasonable care, and this is the objective test of a reasonable man. The question is asked whether a reasonable person in the circumstances would have been able to foresee the harm that Rosa suffered. It is arguable that, as it is well known in the medical circle that cancer is caused by the use of artium, it is highly likely it would be common knowledge, at least in the industries, that the harm would be foreseeable of any person working in close proximity with artium. Therefore, it would be reasonable that the Tate would have been aware of the risks posed by artium and should have taken precautions such as to provide masks to prevent inhalation, make the working spaces properly ventilated, and possibly limited the amount of hours working with artium. And this can be deduced from the case Paris and Stepney Borough Council, where the ratio of the court said goggles should have been provided, particularly given the seriousness of the injury. It is questionable whether the churches would have had the same level of knowledge, but it could be argued that it is logical to provide safety equipment when working with solvents, and foreseeable to a reasonable person that incorrectly handling these could lead to respiratory problems of some kind. The court takes into consideration factors such as the probability of injury, the seriousness of the injury, the cost of preventative measures, and the social value of the activity, which Lord Hoffman describes as a balancing act in Tomlinson. It will be difficult to argue that the cost of providing protective clothing, for example, and the social value and cultural importance of restoring the paintings would have outweighed and balanced the life and seriousness of life-threatening cancer. It is unclear from the given facts whether any precautions were taken by any of Rosa's employers, and if they were taken, whether these would be considered reasonable by a court. On the presumption they failed to do this, a breach of duty may be found, and the next step to establish is causation, both factual and legal. To establish factual causation, the but-for test is usually relied upon, but this can be difficult to establish on the balance of probabilities when it is unknown whether a cumulative or single exposure leads to the development of the cancer. The courts in McGee developed the material increase test, as lack of precautions would lead to more exposure, and this would materially increase the chance of developing the cancer. Although there are multiple sources of the exposure, cases such as McGee and this situation have been distinguished from Wiltshire, where multiple cases were determined not to satisfy the causation criteria because there were different possible causes, whereas this is only one cause with different situations. Fairchild went further to clarify that when different employers were all associated, although it can't be proven which exposure led to the development of cancer, each employer can be found jointly and severally liable, and this was backed by the Compensation Act. Although artium is not asbestos, as is in the case in these precedents, I would advise Rosa that as these cases were decided on policy reasons of fairness and justice, the same may be said of this case. For legal causation, a court assesses the remoteness of the damage and whether any intervening act could have broken the chain of causation. The harm suffered by Rosa is the cancer, which is known to be linked to the exposure of artium and is extremely rare. Therefore, the harm would not be considered remote, and the knowledge of the link between the toxin and the cancer would have been foreseeable as long as this was known and publicised information at the time of the breach. In terms of novus actus interveniens, meaning an intervening act breaking the chain of causation, the negligence of the doctor may be considered. But as in Robinson and Post Office, if the doctor's negligence was not found to be a causal contributor, as but for the doctor's negligence Rosa would still have suffered the harm, this chain of causation would not have been broken. It is rare for acts of third parties to break the chain from the original defendant, as the Civil Liability Contribution Act allows the court to hold all parties responsible. The use of artium in Rosa's personal projects may appear as an intervening act. However, Rosa's personal use was not a separate unrelated act leading to a new damage, as was the case in McHugh, and therefore it would be likely to be seen as contributory rather than intervening. For these reasons, I would advise Rosa that it is likely a court would find the Tate Gallery and the churches she was working with liable, and the burden of proof would shift to the defendants to provide defences. These I will cover later. Mr. Khan owes Rosa a duty of care as established by Cassidy and Ministry of Health. The breach in professional practice cases goes further than the standard of the reasonable person. Boland dictates that the standard is raised to the ordinary skilled man exercising and professing to have the special skill, and thus Mr. Khan as Rosa's doctor is held to a higher standard. He must act in accordance with practice accepted by a medical body skilled in the field. The question is whether other doctors would have carried out more tests or been more thorough in their investigation into Rosa's symptoms and the lifestyle which could have caused these. If the other doctor was able to later diagnose Rosa's condition, I would suggest that this infers that Mr. Khan's practice did fall below the required standard, although it must be considered that as this was later on, the symptoms could have been more developed and therefore more obvious. To find that the duty of care had been breached, a court would have to find that it was illogical to act in the manner that Mr. Khan did when he was diagnosing Rosa's condition, backed by the Belitho decision, and that other doctors found his investigation into her symptoms and the conclusions drawn not sufficient. Factual causation in this situation would be based on the but-for test. However, Gregg dictates that a claim purely for loss of chance cannot succeed. This is the case in Rosa's claim, as the harm caused by Mr. Khan's breach contributed only to the chance of her survival being decreased from 45 to 55% to 10%. Similarly to Gregg, there is uncertainty surrounding the outcome, even with diagnosis and earlier treatment, and also of when the chance was lost. Therefore, following this extremely similar scenario and consequent judgment, it seems factual causation cannot be established in terms of Mr. Khan. As both factual and legal causation are necessary to establish causation in a negligence claim, I would advise Rosa that it is unlikely pursuing a claim against Mr. Khan would be successful. As potentially liable parties, it is up to Rosa's employers, the Tate Gallery and the churches, to prove any defences that they may have to reduce the damages they owe. The defence of Valenti relies upon whether the act was knowingly, clearly dangerous and a necessity, as per Morris and Murray. Rosa, working with the chemicals herself, may suggest she was not fully aware of the risks involved, and her exposure during employment could not be considered a necessity would be considered a necessity and not a free voluntary choice. Corbett and Cumbria Kart Racing Club makes the distinction between consenting to the risk and consenting to the breach. In this situation, working with a solvent and working with the solvent with the correct precautions and protective measures would be different, and it is unlikely this defence would succeed. The Tate and the churches could also attempt to argue contributory negligence, as a partial reduction in recovery due to the claimant's share in the responsibility of the damage. Pitts and Hunt defines this contribution as knowingly accepting and being an active participant to the harm caused. This may be a successful argument in Rosa's case, as the independent use of the chemical may not be considered appropriate care for her own welfare. The requirement of knowledge again requires the reasonable person objective test, and Rosa may argue that the extent of her foreseeability was not the same. But as it has been found in the case of her employers that a reasonable person would have seen the damage of the artium, it is likely it will be found here also. I would advise Rosa that the most likely success of her claim would be against the Tate Gallery and the churches as her employers, and damages would likely to be partially reduced because of the defence of contributory negligence.